Passage 1. Listen to part of a lecture in a business class. Alternative dispute resolution. Now, all of you know that business relations can go sour and that sometimes deals are broken and a solution needs to be reached. That's why I want to talk to you today about ADR, or Alternative Dispute Resolution. Some of you may have talked a little or a lot about ADR in one of your law classes, and that's great. You will find an overlap, and that's okay. ADR is really becoming a viable way to resolve problems without going to court, or it can be a way to shortcut a lengthy court process. So if you have heard of some of this before, listen again, because what you are going to hear today has the possibility of being very beneficial to you in your business endeavors and might even help you in other aspects of your life when there are disputes which need to be resolved. So let's get started. ADR stands for Alternative Dispute Resolution. It's an alternative way to solve problems, a way to resolve problems without the intervention of courts and the legal system. Think about each of the three words. There has to be a dispute. The dispute needs to be resolved. And it is an alternative way to the traditional method of resolving problems in business, and the traditional way is through the courts. ADR is popular in all of the states, and in fact some states permit types of ADR to happen before a lawsuit is filed. Now, not all states allow that, so in most cases we're going to be talking about a process that takes place to try to resolve a problem after a lawsuit has been filed. There are several types of ADR. One of the most popular is mediation. Mediation is a process where a third person, a person who is neutral and doesn't have an interest in what the solution is, plays a role, and a process where a mediator, a neutral, tries to encourage and help resolve a dispute or problem between two or more parties. Now, you all know that court hearings are adversarial. That is, lawyers are representing their parties and present the best case they can for their party. But in mediation, there's a difference. It's a non-adversarial process, and that means that the lawyers take off their hats as lawyers and work with clients to solve the problem with the other party. The process is non-adversarial and it is informal. There are no rigid rules that have to be followed, as in a court proceeding. The objective of mediation is for the parties themselves to decide what is the best way to solve the problem. You know that in a trial that either the judge or a jury will make a decision for the parties. So that is one of the beauties of mediation. The parties are the ones who have a voice in the decision-making process and in the decision itself. It won't be the mediator who makes the decision. It will be the parties themselves. The mediator's role is to help the parties identify issues, encourage joint decision-making, and explore settlement options. Another advantage of mediation is that it is confidential. Usually what happens is this. A lawsuit is filed. Then at some point the judge can order the parties to sit down and try to resolve the issues, or one of the lawyers or a party to the lawsuit can ask the court to order mediation. Now, that part of the process is known by the court, but nothing is told to the court about what is discussed in the mediation session. And sometimes more than one session is needed to work through all the problems. So that's another plus. It's confidential. If the parties don't reach a solution, then there is a report made to the court that there was no agreement reached, and the lawsuit continues. Now, if an agreement is reached, then the agreement is filed with the court, and the agreement is binding on the parties. If a party decides not to follow through with the agreement, then everyone can go back into court, and the party who is not following the order can be punished with some kind of sanction. Another thing, the parties must mediate in good faith. Now, that doesn't mean they have to reach an agreement. They just have to try to reach an agreement. But in reality, a great percentage of the lawsuits which are mediated do get settled outside of court. I am not going to talk about how mediators are trained or chosen or the actual process involved in mediation. If you are ever in a situation where you need mediation, those are things which you can find out then. Also, remember that not all states will have the same rules pertaining to mediation or any of the other ADR methods, but I have talked to you today about the concept of mediation and how it generally is structured. So next time, we will talk about other types of ADR.
Now get ready to answer the questions. You may use your notes to help you answer.
Number 1. What is the talk mainly about? Number 2. In the lecture, the professor describes some advantages of mediation. Indicate whether each of the following is an advantage the instructor discussed. Click in the correct box for each phrase. Number 3. Why does the professor mention the role of the mediator? Number 4. According to the professor, what is one important goal of mediation?
Listen again to part of the lecture, then answer the question.
Some of you may have talked a little or a lot about ADR in one of your law classes, and that's great. You will find an overlap, and that's okay.
Number 5. What does the professor mean when he says this?
You will find an overlap, and that's okay.
Listen again to part of the lecture, then answer the question.
Another thing, the parties must mediate in good faith. Now that doesn't mean they have to reach an agreement. They just have to try to reach an agreement.
Number 6. Why does the professor say this?
They just have to try to reach an agreement.